hit the record button. We're really lucky to have Paul Cohen with us. He is a local attorney who focuses very heavily on all things rental, and he is a very valuable contributor to the Real Estate Coalition. Paul brings his expert knowledge to the table, and he has been a really good resource for those of us in this marketplace as it relates to rentals, and when we're trying to deal with city council and trying to figure out when they're introducing some new legislation that is going to be the latest and greatest, and it winds up causing all of us a lot of agita and headaches. Paul is one of those very clear-eyed folks who really helps us out, as well as helps out city council members to understand, hey, look, that's great, you're going to do this, but this isn't maybe an unintended consequence of that legislation. So we're really lucky that Paul's in our orbit, and we're lucky to have him with us this morning. So Paul, good morning. The floor is yours.
Yeah, good morning. Thank you, Matt. I am an attorney that is licensed in Pennsylvania, New Jersey, and New York. And I'm also a real estate broker that is licensed in Pennsylvania, New Jersey, and New York. So I have that perspective as well. What I would like to do today is answer your questions more than anything else, and talk about what you want me to talk about. As an attorney, I go on and talk for days, not a problem. But I don't want to talk about things that aren't relevant to the people on this call. So if we could, I'd like to think of this as free legal advice, free broker advice that I can help you out with, and more importantly, answer any questions that you guys have. But I am going to go over a couple of things just to make sure that everyone is aware of some of the laws and some of the things that are going on in Philadelphia. It would take me days to explain everything that's going on in Philadelphia, because Philadelphia is very difficult to navigate through from a rental market standpoint, from a landlord standpoint. I guess the key words there are overregulated. Philadelphia is unbelievably overregulated. One of the few major cities in this country is like Seattle. Very difficult to manage real estate from a landlord's perspective. Okay. In looking at the rental market, I have one word for everybody. It's very simple. What you should be doing: sell. It's very difficult to manage property in the city of Philadelphia. I talk to city council all the time, and one of the things I say to them is, if I gave you $1 million and said, here's $1 million, you can invest this money in becoming a landlord in rental properties, where would you buy your first rental property? A, in Philadelphia, or B, not in Philadelphia? What's the answer? Okay, none of them have yet to answer that question for me, because we all know what the answer would be. Because the reality is, it's so hard to be a landlord in the city of Philadelphia. Second question I asked them is, if you had a choice between owning market rate housing or affordable housing that you were going to invest that $1 million in, what would you invest it in? Again, they don't answer the question because it's obvious. The answer is market rate housing does a lot better for you than affordable rate housing. So they all wonder, however, why there's a lack of affordable housing in the city of Philadelphia. Trying to explain to them very simply, it's just so difficult to own rental properties in the city of Philadelphia. If you do own rental properties or already own them, I assume that's people that are on this call. The question is, how do you manage those rental properties? How do you navigate through all the problems with the city of Philadelphia? And if you decide not to sell the property and hold on to the property, what should you be doing? So the first thing I want to make sure that everybody's aware of, because a lot of people are not, is that a real estate agent cannot sign a lease agreement. A broker can sign a lease agreement, but a real estate agent cannot sign a lease agreement. Okay. The bigger problem we have is that someone who's managing a property signs the lease agreement. So this is the real estate licensing laws. If you're working directly for the owner, it doesn't apply. However, if you're working as a management company, which most of you are, then as the management company, the real estate agent is not allowed to sign that lease agreement. That lease agreement must be signed by the real estate broker in your office, or even better yet, if you can get your owner to sign the lease agreement. That's the best way to go. With the owner's signature on the lease agreement, no problem. But if you can't, the owner's out of town, like Greg is all the time, or some other situation is going on where the owner can't sign it, doesn't want to sign it, wants you to manage the property, make sure your broker in the office is signing the lease agreement. Next issue I deal with a lot. And does anyone have any questions on that? All right, seem to be good. I hate these Zoom calls because you just don't get any reactions. Next issue I have a lot is the source of income, Section 8 properties. People ask me all the time, do I have to accept a Section 8 tenant? Very, very difficult question to answer. The reason it's so difficult to answer is that nobody really knows the answer to that question. You're going to hear a lot of people talk about what the answer to that question is and think that they know what the answer to that question is. But the reality is, until the Supreme Court of the United States decides on what the answer to that question is, none of us really know. The different circuit courts throughout the country have ruled differently on this issue. So basically what it comes down to is that in certain localities, like the city of Philadelphia, there's a law that says that you can't discriminate based on the source of income. That source of income is a protected class. So therefore, if somebody has Section 8 assistance, a housing choice voucher, you can't discriminate based on the fact that they get that money from that source of income. Okay, so there was a recent Supreme Court of Pennsylvania case out of Pittsburgh that basically said that because Pittsburgh has a home rule charter, which Philadelphia also has, that based on that, and it's a very complicated case, I'm not going to get into all the details of that, that it's okay not to accept a Section 8 tenant. Because as we all know, when you take a Section 8 tenant, you have to enter into their lease agreement, you have to follow by the rules and regulations. There's so many things that you're obligated to do. From a personal standpoint, I think it's the most ridiculous thing that you have a voluntary program from the federal government which says that you do not have to accept Section 8 tenants. It's a voluntary program. If you want to enter into the program, you can enter into the program. If you don't have to. Yet because states come along or localities come along and say that source of income is a protected class, they want to say that you can't discriminate based on that. And now you're forced to accept these Section 8 tenants. Okay. Personally, I think that's ridiculous, because if it was just here, just accept this money, yeah, that makes sense. But it's not just accept the money, it's accept the money and you have to follow all these rules and regulations. So you can't, like, for instance, you can't terminate the lease at the end of the term unless you have good cause. They do an inspection every year to make sure that the property is up to snuff. If it's not, they stop paying you. They just, flat out stop paying you. They do inspection, you fail the inspection, and you're not getting the rental income anymore. They do a reinspection. If you still fail it, you don't get the rental income. There's just all these rules and regulations that you shouldn't have to follow. Okay. So based on that Supreme Court in Pennsylvania, case in Pennsylvania, you shouldn't have to accept a Section 8 tenant. The problem we have is that there are testers that are out there that are testing to see whether or not you accept a Section 8 tenant. And they believe that not accepting a Section 8 tenant is discrimination. And a lot of them will file a discrimination case against you because you didn't accept the Section 8 tenant. At some point in time, somebody's going to take this case to the Supreme Court of the United States and we'll get a final decision to see whether or not you do have to accept it or don't have to accept it. And until that happens and we get a clear decision, we honestly do not know whether or not you have to accept a Section 8 tenant. So when people ask you that question, the answer is, I don't really know. Okay. I can tell you what is happening in Pennsylvania, like I did, and essentially you shouldn't have to accept the Section 8 tenant in Philadelphia or Pittsburgh. But that doesn't mean if somebody takes that case up to the Supreme Court, at some point in time, Supreme Court rules differently and says you do have to accept that Section 8 tenant. Okay. Speaking about fair housing and staying on that topic, there was a recent case that you may have seen in the paper a couple of days ago, I guess it was last week, that said that this company in Bucks County got hit with a $450,000 fine for discriminating against a particular tenant. The $450,000 is what opened everybody's eyes up, because that number was astronomical compared to what you see in normal fair housing cases. Normally in a case like that, you might see a $20,000, $25,000 decision. Sometimes I've seen them as high as $100,000, $150,000. But to see a $450,000 case was like, wow, what happened? If you've read about it in the paper, basically what they were saying is the person went, applied for an apartment. It was a husband and wife. The husband qualified on his own. The wife was didn't have was not a United States citizen. So she didn't have a social security number. The complex had a hard and fast rule that if you don't have a social security number, you don't qualify for the apartment. The problem was the husband qualified for the apartment. As I'm going to tell you in a minute, you should never have a hard and fast rule about anything. So the fact that they had the hard and fast rule is what ended up getting them sued initially, and there were some other fair housing violations that went along with it. But here's why that case is so important. That person was applying for a first floor apartment. And this, by the way, you won't read in the paper and you won't see anywhere. But this is the backstory to what happened here. Person's applying for a first floor apartment. Didn't get that apartment. They needed an apartment that was close by in that area because they had a job that was close by, and whatever reason they wanted to be close to that locality. The only other apartment that they could find was an apartment on the second floor. The woman was pregnant at the time, and she had 2 kids. Apartment didn't have an elevator, and she ended up walking up and down the stairs and ended up having a problem with her knees, and she needed an operation, and it basically became a personal injury case. And here's why this case is so interesting. What the complainant argued in that case is that not only am I entitled to what they call compensatory damages, or damages to compensate me for my losses, they were arguing that they're entitled to consequential damages. And consequential damages is basically saying that as a consequence of what you did, namely didn't rent me that apartment, something else happened and I ended up with all these additional damages, these additional injuries, this additional problem that cost me money. So what they were saying is we're entitled to consequential damages because you didn't rent me that first floor apartment. I ended up being on the second floor, ended up hurting my knees, and you're responsible for me hurting my knees. It's a stretch. It's the first time that somebody brought a case for consequential damages. The attorney on the case is an attorney that worked for HUD, was pretty high up at HUD, and is very familiar with fair housing laws, tied in with the attorney general, really knows what she's doing. One of the few people that I really respect in the industry that actually understands fair housing laws, and I can have a decent conversation with them. She wanted to prove that in fair housing cases, you're now entitled to consequential damages, and wanted this case to go to the Supreme Court of the United States to get a decision on it. The case ended up settling. The insurance company ended up settling the case. They settled it as if there was the consequential damages piece of it, not 100% of what the plaintiff was asking for. But as you can see, based on the fact that it was $450,000, they gave them a lot of money based on the fact of the consequential damages. What this does now is not only does it embolden this attorney to bring other cases and argue consequential damages, other attorneys that start to see this case and actually understand what happened in this case will start doing the same thing. We don't have a court decision on whether or not consequential damages will be allowed in fair housing cases, but there's now a settlement precedent, if that is a precedent. It's not a legal precedent, but it's out there that this has happened, that you can be sure attorneys are going to be latching onto and arguing in any similar case. So what normally would be a relatively small, though you might not think 100 or 150,000 is small, but a relatively small case now is going to balloon into a large case. And God forbid somebody dies, you have a wrongful death case as part of that consequential damages. Who knows where the number could go? So the bottom line of all that is twofold. Number one, make sure that you don't discriminate. And number two, make sure you have adequate insurance. And the key to this case, or the key for this client, was they had insurance which covered that claim. Recommend to everybody, look at your insurance policies. A lot of insurance policies have exclusions for various types of fair housing claims. Talk to your insurance agent, make sure that you're covered for all types of fair housing claims, including claims for consequential damages, so that if that does arise, at least they'll be covering you and you'll be protected. Okay. The other thing I want to talk to you about with regard to fair housing is that you should not have any absolutes. That's what gets you sued. So anytime somebody's calling in, and what's happening now is there are a lot of testers that are out there, testing organizations, and they just pick up the phone and start calling. And they will ask you questions like, do you provide a reserved parking spot for a tenant? So if you have an apartment complex, you have 10 units, whatever it may be, you have a parking lot there, you have handicap spots, but they're going to ask you, do you have a reserve spot? If you just say no, we don't offer reserved spots, and they're going to give you some type of a situation where the person needs a reserved spots, they're handicapped, what have you. If you just say no, boom, you're going to get sued. Plain and simple. You can't just say no to any of those fair housing questions. Every single situation, you need to evaluate it on a case-by-case basis. So in that situation, you would tell them that they need to apply for the apartment, let them make a reasonable accommodation, and you'll review it. They'll go away at that point in time. At least the tester will go away. Okay, if it's a real situation, then what you should be doing is actually reviewing it. Is what they're asking for reasonable? May or may not be. What's the definition of reasonable? Nobody really knows. Reasonable, as my partner always says, reasonable is what doesn't get you sued. So you basically just have to work something out with the tenant, get the buy-in from the tenant, and you're all good. So whatever you can work out with the tenant, get it in writing, you're good. You provided the reasonable accommodation, you're okay. But don't have that hard absolute. And where that landlord in that other case I was telling you about got in trouble was they said, nope, we don't accept anyone without a social security number. Hard absolute, got sued, major problem. All right, I see we have some questions. How is Section 8 funds a source of income if it's not paid directly to the tenant, not claimed on tax returns? The source of income, of course, they said, the source of income piece is that you can't discriminate based on where your tenant receives money or how they receive their money. So if they're receiving their money through the government, then you have to consider that as part of their income. You can't say that I have an income requirement that says you have to make 3 times the amount of your rent on a monthly basis. Three times the amount of the monthly rent in your gross income or whatever criteria you have. You can't exclude the money that they're getting from Section 8. That Section 8 has to be included as funds available to pay the rent. That's where the source of income law comes from. Of course, they settled, right? I hear you on the, of course, they settled, but it wasn't like they settled for $100,000 or $50,000. You know, they settled for $450,000. That's a lot of money. That's just not a, okay, we're going to settle this case and go away for a couple of dollars. They settled it for a really high number. So it's something that the insurance company may have wanted to fight. Quite frankly, I'm glad they didn't, because I don't want to see a legal precedent on that issue. That would really be bad if that came down. Can a landlord say they will accept a PHS Section 8 tenant? I assume they're talking about a PHA Section 8 tenant. Yes, you can certainly accept a Section 8 tenant. If you want a Section 8 tenant, that's great. You can accept them and enroll in the program. You have to go to classes, get certified by Section 8, and then you can certainly enter the program. Can you charge higher than HUD to find fair market value and rental if the Section 8 tenant is willing and able to pay? That gets tricky, and basically no, that creates a problem. If you're going to enter into the program, you have to charge the rents that they're allowing you to charge. I can tell you that in talking with Section 8, they have increased the amount of rents that they're allowing. They realize that the rents are low and nobody wants to be in the program because the rents are so low. So they are getting back up to the times and realizing that they need to increase the rents. In my opinion, they're still not where they need to be. They still need to be a lot higher, but hopefully they'll get there. I was going to say they will not accept it. So you don't want to come out with the question is, I was asking, can they say they will not accept anyone except a Section 8 tenant? So technically you can do that because you're not the person that is paying market rent is not in a protected class. The protected class person is the person that's getting the Section 8 assistance. So in theory, you can say you will not accept anyone except the Section 8 tenant, but I wouldn't do that because there's other ways that creative attorneys can figure out that that's still discrimination. You have various ways that you can get around the discrimination laws. So if there's an intent to discriminate, that could be considered discrimination. Somebody can make the argument that the source of income is your money that you're receiving from your job. You're discriminating against me based on the fact that my source of income is from my job, and therefore that's still discrimination. So I wouldn't do it. As I said before, any absolutes will get you sued. So if you kind of just think in those terms, don't have absolutes, that's the best way to go to avoid being sued for a fair housing violation. All right, that's pretty much the fair housing issues, unless anyone has any other questions on fair housing. Can you refuse to accept PHA based on program rules? So no, not specifically based on the program rules. That's kind of what I was saying earlier. I personally think you should be able to do that. It makes a lot of sense that you should be able to do that, but unfortunately, that's not the way the court decisions are coming down. You cannot accept it based on the case down in Pittsburgh, where the Supreme Court of Pennsylvania ruled that you didn't have to accept it if you have a home rule charter, which Philadelphia does. You can also sort of say that you haven't been qualified to be able to accept Section 8 tenants. In order to be able to accept a Section 8 tenant, you have to go through training through PHA. So if you haven't gone through that training, you aren't allowed to accept a Section 8 tenant. So you can just tell them you haven't gone through the train, you can just tell them you're not qualified yet to accept Section 8 tenants. But again, on that initial phone call, you just don't want to say, absolutely, I don't accept Section 8 tenants, because that's what gets you sued. Okay, moving on. Just wanted to touch on taxes and your real estate taxes and give everybody a little background that you may not be aware of on why you're seeing that real estate taxes have been going up. You see 20%, 50%, some ridiculous amount. So let me explain to you what actually happened with AVI, Actual Value Initiative, when that got passed way back when the city decided to go to that program. So basically what you have in normal localities is that when you want to do a countywide reassessment, the countywide reassessment has to be revenue neutral. What does that mean? That means when you reassess the taxes for everyone across the board, some people are going to be paying more in taxes, some people are going to pay less. When you have a situation where most of the property values have gone up, most of the people are going to be paying more money. So in theory, that would give more money to the locality in tax revenue. When that happens, the millage rate is supposed to be adjusted downward so that the money that the locality gets ends up being the same as the money that they got before they did the countywide reassessment. There's a certain small percentage that they can get in an increase, but it's very small, it's nominal. And the purpose of a reassessment is basically to make the property values more equal across the board so that people whose property values are going up will pay more. People's property values have gone down will pay less. And it's to adjust that. It's not to raise money for the locality. Philadelphia's AVI, Actual Value Initiative, when they came out with it, does not require that the city have a revenue neutral tax adjustment when they do reassessment. So the city has the ability to do reassessments that actually make the city money. When the city does reassessment, property values are going up, the revenue to the city goes up. They don't have to readjust the millage rate down. So what the city did, off the record, although this is being recorded, so I guess it's on the record, what the city did was they evaluated the properties at a lower number when they did the AVI initially across the board. Why? Because they were able at that time to get a higher millage rate, saying to people, here's the millage rate, here's the taxes you're going to pay. And people that had a lower tax number than what their property was valued at, which was most of the people, because that's what they did, said, oh, this is great. I love AVI. They came out, they reassessed my property, they reassessed it wrong. I'm good. I'm not saying anything. I'm not complaining. I'm happy. But keep in mind what the city did was because they had all the property values low, they were able to come up with this higher millage rate. Now what you're seeing is, since AVI is, they're readjusting the property values. And what happens when they readjust the property values? City makes more money. Why? Because they're not required to lower the millage rate. So the millage rate stays the same. On the other side of the equation, the property values are going up. City's making more money. It's actually brilliant what the city did. And people that wanted to complain, they're saying, hey, my property values, I got reassessed, it's all this money. And the city's going back to them and saying, yeah, you should have been paying more money before. Your assessment was lower. You shouldn't be complaining because you didn't pay what you were supposed to pay before. But the reality is you did, because you were paying a higher millage rate. So that's kind of what's happening now with AVI and with the city and the reassessments. You'll notice that the millage rate hasn't gone up, right? since AVI, millage rate hasn't gone up. Politically, it's very hard to raise taxes, right? It's hard to raise the millage rate. It's hard to say we're going to charge you more money in taxes for your property. It's easy, or easier, although you're seeing this big backlash, but it's easier to say we're raising your property value because this is what it should be. And you were paying it too low before. So that's kind of the backstory of what's happening with AVI. Just looking to see if I have any other questions. I think we're good. Hopefully that kind of clarifies what's happening there with the city and the taxes. Yes, you still should be complaining because what they're raising your taxes is still crazy. And if anything, the millage rates should be going down to adjust for it. But don't hold your breath for that one. I was talking before about the problems of being a landlord in the city of Philadelphia. And the fact that the city of Philadelphia is just overregulated. I have a book somewhere on that shelf, this thick, of all the regulations in the city of Philadelphia and what a landlord needs to do to comply with all those regulations. As Matt said, I do a lot of work with city council, and they come up with these new bills all the time. And the first thing I do is I bring my book in and I say, you do know that this is already covered in the law. There's laws that cover all these things. And they say, yeah, it's covered in the law, but nobody's really enforcing that law. And I'm like, well, okay, they didn't enforce that law. So now you're going to pass another law? Are they going to enforce that new law? Just go and enforce the law that's already there. But no, it's not politically popular to do that. It's more politically popular to say, oh, here's what we're doing. Here's how we're fighting for land tenants. And this is what we're going to do to help our tenants. So next thing you know, there's a new law. So just want to run through them quickly. I'm not going to go into detail on them. I do probably an hour seminar on each one of these laws, but it's something that you should be aware of. So I just want to kind of touch on it, mention it. And then you should just make sure that you're doing it. If you're not doing it, find out what the laws are in detail to make sure that you do comply with all these things. So first thing, when you own a rental property, is you have to have a rental license, housing license. It's kind of interesting. It used to be called a housing inspection license. They never do the actual inspections. So they realized that they needed to take out the word inspection because they don't actually inspect the property. They just charge you a fee for it. It's basically a moneymaker for the city. Personally, I think it's unconstitutional. I wanted to challenge it years ago, but landlords said, don't do that, because if you challenge it, the end result's going to be they're actually going to do the inspection to justify the fee. And we're happy the way it is. So we kind of just let it go. It did recently go up an additional $5. Used to be $50. They kind of snuck that in. It's now into the budget. It's now $55 to get your housing license. So when you purchase a property, you have 10 days. This is interesting. You have 10 days within which, under the law, to go get a housing license. However, the law says if you don't have a license, you can't collect the rent. So query, can you collect the rent for those 10 days? Nobody's ever brought it up as an issue. I personally think that's a problem, because if you don't have a license, you can't collect the rent. But the bottom line of it, for your purposes, as soon as you buy a property, rental property, make sure you get the housing license immediately so you don't run into that problem. Next license you need is a certificate of rental suitability. That's basically another certificate that basically does the same thing that the housing license does. What they did when they initially introduced that legislation to have the certificate of rental suitability, they actually wanted to then get the inspection done through that separate license. Kind of ridiculous, because you already have the housing license and you want to do the inspection, have it under the housing license, but now they want to have a new license with a new fee for the inspection. I actually personally challenged that in court. We reached what's called a consent decree in that case, which basically watered it all down so that at this point there is no charge for it. and it's self-certifying, meaning you as the landlord have to certify that your property has no violations. You need to get that certificate, however, before you rent the property. It's kind of duplicative because you already have the housing license, but it's just another license that is required, and something that we allowed to happen at that point with part of the consent decree, because we got everything else that we wanted in that agreement, including not having to pay a fee. But it's something you need to make sure that you have, because if you don't have it and give a copy to the tenant, you cannot collect the rent. Very important. So make sure that you have that and give a copy to the tenant before you rent the property. Okay. If you don't have that license and are collecting the rent, the tenant is still paying you, you do not have to give that money back to the tenant that you've already collected. That was a huge decision that came down by the courts. But if they're not paying you, you can't collect the rents and you can't go to court. You cannot file in court to evict that tenant. So you want to make sure you have that license. If you don't, then and you need to evict the tenant because they're not paying, what you're going to need to do is get that license right away. And then once you get that license, you can then go to court. The court will only allow you to collect the rent from the date that you got the license forward. The period of time that you didn't have the license, you will not be able to collect the rent. So make absolutely certain that you go and get your certificate of rental suitability. Next license that you need to get is the lead paint certification. So previously, you only needed to have a lead paint certification done if you had a child 6 or under living in the property. City argued that landlords weren't complying with the law. So because the landlords weren't complying according to their statistics, they said, you know what, the only solution that we can come up with is we're just going to make every landlord get the certificate of lead safe for the property, or lead free. Okay, and hopefully you all know the difference between lead safe and lead free. Lead free is there's no lead at all in the property. Lead safe means there is lead in the property, but it's safe, it's encapsulated, it's not creating a problem for the tenant. Okay, you now have to get a certificate for every single property. Make sure that that's getting done. If you don't have a lead safe or lead free certificate, not only can't you collect the rent, but the tenant can sue you for all the rent they've already paid. So as opposed to the certificate of rental suitability, where if you're paying the rent, that if the tenant's paying the rent, then you can keep that money. With the lead certificate, if you don't have one, the tenant can sue you for that back money. So that is really important that you get that lead safe or lead free certification and have the tenant sign off that they've received it. This has created a cottage industry for attorneys because they can also get attorney's fees. So attorneys are realizing that there's a lot of money to be made on all these landlords that haven't given lead safe or lead free certifications, and they're filing lawsuits against landlords to recover that covered money back. Yeah. You know what I'm saying? To get not only not for them not to have to pay going forward, but they sue to get all the back money as well. So that's very important that you have that. Questions? Home rule charter puts a cap on real estate tax increases. So if the increase exceeds that cap, this is a violation of the rule. Correct. I'm not sure about whether or not that's in the home rule charter. I will have to check on that. I don't know the answer to that question. I know they were talking about passing a bill to limit how much they could increase the taxes, but I haven't seen anything in the home rule charter that says that, but I will certainly take a look. Joe told us she wanted the suitability cert signed by tenant and delivery was not enough yet. Judge Gilbert, not surprised. sorry, I should probably read that question. The judge told me she wanted the certificate of rental suitability signed by the tenant, and delivery was not enough. The problem is you have to prove that it was delivered, and the judges in Philadelphia are finding any way possible to rule in favor of the tenant. So there's a new diversion program, which I'm going to get into in a little bit. But suffice to say for now is that in the diversion program, they snuck in a section that says that the judge sua sponte, which means that the judge on their own can now raise issues on the tenant's behalf. So in a normal court case, you would think the judge is neutral. The judge isn't for the plaintiff, the landlord, or the tenant, as the case may be, or for the other side. The judge doesn't favor one side or the other. So when you present your case, if there's no defense to the case, you generally should win. However, what the law says in the Diversion Act, Diversion Ordinance, it says that the judge, sua sponte, on their own, can raise issues on behalf of the tenant. Absolutely absurd. Now the judge is basically acting as an advocate for the tenant. Crazy. Something that we might be challenging at some point in the future. But for now, that's what's happening. So you could have a case where the tenant doesn't even show up, where you would normally get a default judgment. You filed the lawsuit, you go to court, tenant's not there. You should win the case automatically. However, now the judge can actually look to make sure that you're complying with all the laws. So the judge on their own can look, do you have a certificate of rental suitability? Did you get it? Did you give it to the tenant? Did the tenant sign it? Can you prove that the tenant actually received it? Do you have a certificate of rental suitability? So you absolutely positively want to make sure that you have these things, and you want to make sure that, to Greg's point, that the tenant is signing off on it, because you have to prove, it's affirmative burden. You have to prove that the tenant received it, because the tenant's going to come to court and say, I never got it. You never gave that to me. And the judge most likely is going to side with the tenant, unfortunately, because they are looking for every reason to allow the tenant to stay in the property, which, by the way, is a national movement to keep tenants in properties and not have them being evicted, and is a movement that's sweeping the country. For those of you who've read the book Evictions by Matthew Desmond, he's now has a cult following. He's like a cult hero among tenant advocates, basically arguing that evictions are the cause of social problems, not a symptom of social problems, meaning that the evictions actually cause the harm to tenants to not allow them to rent another property, which causes other social harm, because then they end up on the street and yada, yada, yada. When in reality, evictions is a symptom of something else. What's a symptom of? It's a symptom that the person doesn't have a job. They lost their job. The economy is really bad. They're not able to get income to be able to pay their rent. That's the problem. That's what you need to solve from a social standpoint, not stop the evictions when someone's not paying and force the landlord to bear the burden of that. Can you give the certificate after they moved in? The answer is yes. You can give the rental certificate at any time, but be advised that if they haven't paid you, then any rent that they haven't paid you up until you give them that certificate, you're not going to be able to collect. So you want to give them their certificate before they move in. If they haven't, if you have any tenants now that don't have a certificate of rental suitability, go get one right away and give it to the tenant. As long as they're have been paying you, no harm, no foul, you're good. If they haven't been paying you, then that's going to be a problem, because up until that date that you give them the certificate, you're not going to be able to collect the rent. Airbnb units for short-term rentals need a rental license, ? There's a new license that they are required to get, which is a whole nother seminar. But yes, you definitely have to get a separate license for short-term rentals and pay taxes. Would it be considered a conflict of interest if I, as a realtor, became a certified lead tester to offer that as an extra service to my landlord clients? No, that is fine. You absolutely can become a lead tester. In fact, the landlord themselves can become a certified lead tester and do the testing and certify it. That's not a problem, and it's probably a good idea. Is an email enough to show they received it if they send a copy of every document they need? So there's no hard and fast rule as to here's the documents that you need to prove that the tenant received something. Think of it as you're going to be in court and the judge is going to ask you these questions and you're going to have to prove to the judge that they received it. So you sent an email. If you have a received receipt on the email, something else to show that they received it, some acknowledgement, you're better off. Having just sent the email, tenant comes in, the tenant's going to argue whatever they're going to argue as to why they didn't receive it. And now you got an argument going back and forth. The key is you want to avoid arguments in court. You want to avoid having to go to court. So you want to do everything possible to be able to prove that the tenant received it. Best way to do that is make sure they sign off on it. Can you give the rental suitability to a tenant that already lived in the property? I answered that question. I see. Well, is there also another certification for bed bugs before the tenant moves in? Yes, I was getting to that. So we'll talk about that now. You need to certify whether or not there was a history of bed bugs over the last 4 months before you rented the property, 120 days. And that has to be given to the tenant as well. It's another certification that's required and the tenant should sign off on that. And there's also a bed bug brochure that has to be given to every tenant. And there's also a Partners in Good Housing from the City of Philadelphia brochure that has to be given to the tenant. And the lead pamphlet, the federal one, also has to be given to the tenant. So I'm saying it's amazing how many things you have to do to comply with all the laws in the City of Philadelphia. If you have fire escape in the property, you have to make sure that you do a fire escape inspection periodically. And if your building is above, and I don't know off the top of my head, I can't remember the exact amount of feet, but if your building is over a certain height, you also have to have a facade inspection done. If your property is being rented out for less than 1 year, you also cannot evict that tenant, or I should say terminate the lease at the end of the term unless you have good cause. There is a good cause law that exists in the City of Philadelphia. Similar to New Jersey, if anyone has property in New Jersey, and it's similar to your Section 8 Housing Choice Voucher properties, where you can't just terminate a lease at the end of the term. If your lease is for less than 1 year, you have to have good cause to terminate that lease, which is why I strongly recommend to everybody, do not have any leases for a term of less than 1 year in the City of Philadelphia. Having said that, that's from a legal standpoint. From a business standpoint, if you can charge more rent because it's a month-to-month lease or a short-term rental, and you charge more than you do on a yearly rental, I get it. From a business standpoint, it's just a determination that you can make so that from that business standpoint, you can make more money on a short-term rental. But from a legal standpoint, if you're charging the same amount of rent, absolutely make sure your leases are for 1 year and make sure the renewals are for 1 year. Because if the renewal is month to month, you're in the same situation. You cannot terminate that lease at the end of the term. Why is that important? If you have a tenant that is a bad tenant, but you're not able to evict them because they don't rise to the level of something that's bad enough that you're going to be able to prove in the City of Philadelphia, and the judge is going to say that's bad enough that we're going to go ahead and allow you to evict the tenant, the only way or the best way to get rid of that tenant is to just terminate their lease. But if it's a month-to-month lease, you can't terminate that lease unless you have good cause. That's the problem. So 1 year or longer lease, then at the end of the year, terminating your lease, don't need to have a reason why I'm terminating it. And that's the end. They have to leave. And by the way, don't give a reason why you're terminating it. If you're going to terminate it for end of the term, it's the end of the term. You decided that you're not going to renew the lease, period, end of story. The reason I say that is, while you can absolutely terminate a lease at the end of the term, if you want to, if you're terminating it for the wrong reason, then you can't terminate the lease. So if you're discriminating against them or doing something else that's illegal, you can't terminate the lease. So the best thing to do in that situation is not give the reason, because you may fall into the trap of giving the wrong reason. If you don't give any reason, you have the absolute right to just go ahead and terminate the lease. Do that at the end of the term. Just terminate it. Don't give them the reason. They may ask you, why you're terminating the lease. That's a decision that you made. You want to move on, whatever. Don't give them a reason why you're doing it. Just terminate the lease. But make sure you don't have those month-to-month leases. See, there's some other questions. Do we need to retroactively give the bed bug certificate to tenants who had a lease prior to the new requirement that has to be given? No, you don't have to retroactively do that. You have to do that for new leases. Isn't it true that landlords cannot rent to more than 3 unrelated tenants? If so, how do student rentals occur with unrelated households of 4 or more? That's basically what the law says, but it's very hard for them to enforce that law. And then there's a lot of discrimination issues that come into play here. It would take me an hour to go through all the different issues that are involved with this. And it gets into familial relationships. It gets into gender issues. What does related mean? If 2 people are in a relationship, is that okay? Are you discriminating against them because they're not married? There's all sorts of things that come into play. So that's a really tricky question, but for the most part, the city is not enforcing that. So you don't really have to worry about it at the moment. And Stephen said, yeah, never give a reason. Exactly. That's the best way to go there. I see we're getting close to 9 o'clock. Is there any other questions before we wrap this up that I can answer for anyone? Free legal advice, take advantage. So while I'm waiting for that, there is a woman goes to her lawyer and says to the lawyer, how much do you charge for 3 questions? And the lawyer says, $500. She says, $500 for 3 questions. Don't you think that's a lot of money? He says, yeah, probably it's a lot of money, but that's what I charge. And what's your 3rd question? Sorry. It's hard to tell jokes on Zoom because you don't get any reactions. But I crack myself up. But yes, any other questions? Happy to answer. Cell phone close me. Thank you. Thank you. I think we're good, Matt. Oh,
all right, Paul. All right, we got one. There you go.
What if the rent we charge is higher than Section 8 fair market rent? Can we charge that if Section 8 tenant is willing to pay the difference? You can sort of try and get away with that, but be careful with that because Section 8 frowns on that. You're not supposed to be charging more than the actual amount that they've appropriated. So from a legal standpoint, it's no. From a practical standpoint, if you get away with it, that's great. I think we're good to go.
All right, Paul, great job. Great questions from everybody. That was really great. Very straightforward. We got some great feedback on a variety of topics. Paul, that was just awesome. You joined us last year. Hopefully we can get you back in again sometime in the future. because this is really a great turnout, great content, and we're very grateful for you sharing your expertise with some free legal advice today. So again, let's give a little round of applause to Paul. Thank you very much, Paul. Everyone, remember, tomorrow we have 10 o'clock Coffee Talk, President Jake, and we're going to have a great researcher from NAR letting us know more about the clients that you serve and where the marketplace is with them and how that can help you out with your business. So with that, everybody have a great day. Go Phils. Enjoy that sunshine and take care.
Thanks, everyone. Bye-bye.